Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, I told you after we got this video done, where we finally got our hands on the Duncan v. Bonta opinion, that we would be doing more videos after we had a chance to really digest it and start giving it to you in little pieces that you could digest also to help you better not only understand this ruling and the significance of it, but actually to help educate yourself moving forward, because this battle is a long way from being done. I want to talk to you today about a myth that was created years ago, a myth which has been perpetuated amongst the civilian disarmament group, and a myth which has actually led to this whole new legal phenomena called in common use for self-defense, which in and of itself is a farce. I'll explain all of it, so will Judge Benitez. So today, let's spend a few minutes and let's talk about debunking the 2.2 shot myth. Okay, here's what we're talking about today. There is a myth out there. It is a myth that was created many years ago. We're going to explain where it came from. And it is a myth that's based on a statistic. We will tell you where that statistic came from in a moment, that on average, only 2.2 shots are fired in a self-defense situation. Now, what's the importance of that? Well, the importance of it is those in the civilian disarmament regime will tell you that nobody needs a magazine which holds more than 10 rounds because you're only going to use on average 2.2. And unfortunately, if you accept that way of thinking, then really couldn't they argue effectively for 3-round magazines, okay? Now, where does all of that come from? We're going to talk about that because, you see, Judge Benitez, in the case of Duncan v. Bonta, which just came out the end of last week, well, he was as critical of it as we are going to be today. We're going to help you take it apart just like Judge Benitez did so that you can understand where this crap actually comes from and what, if any, weight it should be given. Okay, so as Judge Benitez put it, where does the 2.2 shot average originate? There is no national or state government data report on shots fired in self-defense events. There is no public government database. And so instead, what the state of California relied upon, and this goes back in our time machine now 6 years. This goes back to the case of Duncan v. Becerra when this challenge to the magazine ban first began, okay? Because there was the expert opinion via declaration of a Lucy Allen. And it is Miss Lucy Allen that has come up with this 2.2 number. Now, who is Lucy Allen? Well, from her declaration filed 6 years ago, this is who she is. I am a managing director of NERA Economic Consulting, a member of NERA's Securities and Finance Practice, and chair of NERA's Product Liability and Mass Tort Practice. NERA provides practical economic advice related to highly complex business and legal issues arising from competition, regulation, public policy, strategy, finance, and litigation. NERA was established in 1961 and now employs approximately 500 people in more than 20 offices worldwide. Okay, so I want you to understand that the person responsible for this number has absolutely no expertise whatsoever in firearms, no expertise in law enforcement, no expertise in self-defense, no expertise in anything related to anything that we are talking about. On top of that, as Judge Benitez noted, one would expect to see investigatory police reports as the most likely source to accurately capture data on shots fired or number of shell casings found, although not every use of a gun in self-defense is reported to the police. As between the two sides, while in the better position to collect and produce such reports, the state's attorney general has not provided a single police report to the court or to his own expert. And Miss Allen had testified that she had asked the state for law enforcement data to help her with this research, and they gave her none, as Judge Benitez pointed out. Without investigatory reports, the state's expert turns to anecdotal statements, often from bystanders, reported in news media and selectively studied. She indicates she conducted 2 studies. Based on these 2 studies of newspaper stories, she opines that it is statistically rare for a person to fire more than 10 rounds in self-defense and that only 2.2 shots are fired on average. So that is the basis of this opinion. And I know many of you are already beginning to roll your eyes, okay? And your gut instinct is correct because the law treats evidence like this as well, as Judge Benitez pointed out. Unfortunately, her opinion lacks classic indicia of reliability, and her two studies cannot be reproduced and are not peer-reviewed. Reliability and validity are two aspects of accuracy in measurement. In statistics, reliability refers to the reproducibility of results. Her studies cannot be tested because she has not disclosed her data. Her studies have not been replicated. In fact, the formula used to select 200 news stories for the Factivia study is incomprehensible. And so this is what the crack research came down to for Miss Allen. She used a word search program called Factivia to search through news stories where she gave a parameter as to the years, and then from there selected certain stories to include in her data. I'm not making it up, as Judge Benitez found. Allen does not list the 736 stories, nor does she reveal how she assigned the number of shots fired in self-defense when the news accounts use phrases like the intruder was shot, but no number of shots was reported, or there was an exchange of gunfire, or multiple rounds were fired. She included in her 2.2 average of defensive shots fired incidents where no shots were fired. Now think about that. You are just cherry picking words from stories and including in the data all the times in which the firearm never had to be used. So how many times did a zero go into that equation? Justice Benitez also pointed out, when the exact number of shots fired was not specified, we used the average for the most relevant incidents with a known number of shots. For example, if the story stated that shots were fired, this would indicate that at least 2 shots were fired, and thus we use the average number of shots fired in all incidents in which 2 or more shots were fired and the number of shots was specified. For the Factivia study, there is no way to check her analysis or her math. And once again, she includes in the average those events where no shots were fired, bringing the overall average down. But beyond those concerns, Judge Benitez also pointed out, Allen's 2.2 shot average is suspect for larger reasons. The whole statistical exercise is based on hearsay, anecdotes upon hearsay news reporting rather than police investigatory reports. A database of news articles lacks the usual indicia of accuracy and reliability of admissible evidence. And this gives me an opportunity to kind of geek out for a second, because with evidence, okay, when we are admitting evidence into court, there are 2 questions, okay? The first question is one of admissibility. Is the evidence even going to be admitted at all? And that gets into the rules of evidence and things like that. Now, in a bench trial where this matter was handled, oftentimes the rules of evidence are relaxed. I'm not going to geek out on all of that, why it happens, okay? However, once it's admissible, there's still the finder of fact has to attach weight to it. And so otherwise, evidence which may be admissible may be given no weight because, well, it just stinks to high hell, as Judge Benitez put it. The court is aware of its obligation to act as a gatekeeper to keep out junk science where it does not meet the reliability standard of Daubert. In a bench trial, the relevancy bar is low and Rule 702 is to be applied with liberal thrust favoring admission. While opinions and evidence may have been deemed admissible in some cases, the evidence has been given very little weight or no weight at all. This is the fact finder's role. Challenges that go to the weight of the evidence are within the province of a fact finder. So while questionable expert testimony was admitted, it has now been weighed in light of all of the evidence. And for anybody, whenever we are going to try to deem the credibility, what weight do we want to give to expert testimony, the 4-part test we look at is this. 1, whether a theory or technique can be tested. 2, whether it has been subjected to peer review and publication. 3, the known or potential error rate of the theory or technique, and 4, whether the theory or technique enjoys general acceptance within the relevant scientific community. And of course, with that in mind, the good judge found Allen's study relies on unverified, uncorroborated, second or third hand anecdotal information. So you can see that this entire theory and this entire argument that only 2.2 shots are used in self-defense situations was literally created out of thin air. It relies on absolutely no data, zero data whatsoever. Doing a word search across news articles is not data, okay? Rather than rely on law enforcement, Department of Justice, FBI, any people who actually collect crime data, no, instead we got a statistician with no knowledge of firearms to just cook up a theory by pulling words off the internet. And see, then if you're willing to believe in this 2.2 myth, then you'll also believe what Alshie says, which is that 10 shots or more are only used in 0.3% of all self-defense shootings. However, Judge Benitez pointed out, and this is important, and I want you all to understand that, is that if you take a look at the Center for Disease Control numbers on defensive firearm use in a given year, they estimate somewhere between 500,000 and 3 million incidents occur per year. But listen, even if there was only 500,000, if you multiply that by 0.003, guess what? That means there's 1,500 self-defense incidents that occur annually. And if the number is closer to the 3 million and you multiply that by 0.003, well, guess what? Now we're looking at 9,000 incidents annually. And that is significant numbers. So the bottom line is this theory that only 2.2 shots are fired in lawful self-defense situations is complete fabrication. It was literally made up from thin air. And therefore, the legal theory that we've seen from judges like Karen Ermagert down there in Portland, Oregon, that says we're talking about in common use for self-defense. Yeah, that fictional legal theory is actually based on a fictional statistical theory. Listen, if you have any more questions about this, we'll link up Duncan v. Bonta down below so that you can read it. If you want to get a hold of Washington gun law, you should know how to do that. If you don't, that's okay. That information is right down there in the description box also. Now, in the meantime, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.